All right, that could go on for a while. Experience the long-lasting freshness of Clorox Scentiva, now available in Clorox Scentiva Lavender Scented Bleach. Use as directed.
This episode is brought to you by Nerds Gummy Clusters, the sweet treat that always elevates the vibe. With a sweet gummy surrounded with tangy, crunchy nerds, every bite of Nerds Gummy Clusters brings you a whole new world of flavor. Whether it's game night, on the way to a concert, or kicking back with your crew, unleash your senses with Nerds Gummy Clusters.
Those little forms you guys do mean nothing to me because you can make them up after you get sued. Unless that side has a copy of it, please don't think for one moment that I can trust those forms.
This is the plaintiff, Gregory Moore. He says the defendant towed a loaner car he had from Lexus for no good reason, and he's here seeking justice. The defendant damaged the loaner car. He now owes Lexus a lot of money for the repairs, and he's suing this careless tow guy for the $5,000 he surely owed. This is the defendant, Justin Graves. He says the plaintiff was blocking a driveway. He was ticketed by the cops, and then he towed him. He didn't damage the car. The plaintiff did somehow, and he's now trying to blame him because he owes Lexus for the repairs. Pay him $5,000? Hardy, har. He's accused of a terrible tow.
All parties, please use your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Millian in our forum, the People's Court.
Be seated. Come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome,
Gregory
ma'am.
Moore, you are suing Justin's Towing and Storage, represented here by Justin Graves, for $5,000 in damage to the car that you were driving that they towed, plus also pain and suffering. Tell me what happened.
Well, when I went to go from my parking place, I noticed that the car was gone, and I was stunned. When I called,
Where had you parked?
I parked legitimately on 161st Street and 128th Avenue in Jamaica, Queens.
Why was the car towed?
It was towed for blocking or obstructing the entryway of a driveway.
An entryway of someone's personal driveway?
Yes, yes.
Was it a business or was it a house?
It was a residential home.
And how did you guys get called?
A resident from the home has to actually make a complaint to 311 or the local police precinct. Then after the vehicle is summoned by a NYPD official or a traffic agent.
It's ticketed?
Yes, after it's ticketed, they could determine on their own if...
Who calls you, the police or the resident?
The resident.
So what happened in this case? The resident called you?
The resident got the vehicle ticketed. They called us to tow the vehicle away. We towed the vehicle away.
Did you personally do the tow, or this is one of your employees?
No, one of my employees.
Do you guys take pictures before you tow?
We just mark the receipts on the damages that are on the vehicle.
According to the police, you were parked blocking the driveway.
Your Honor, I was not parked driving.
I mean, even by a couple of inches is a problem. You know that, right?
Yes, ma'am.
Okay, so that's the tow and how the tow happens.
Mm-hmm.
I think your real beef is, I know you keep trying to say you're innocent for the tow, but your real beef is that when you picked up the car, you had a problem. And what was that problem?
Oh, when I picked up the car was damaged from the tow job.
And then what happens?
They told me that they had the vehicle, they wanted the money, to release the vehicle. So I paid the money. And there's an exchange. I said, you guys come into the community and nefarious practices, taking our property, knowing that vehicle was not illegally parked. There's an exchange of words. The police come.
Why do you suppose the police ticketed you, though?
There's like a little gate that represents a walkway. Perhaps the officer assumed in the night that was a driveway, but in fact, it was not a driveway.
Okay, so you go to pick up the vehicle, and you have an exchange of words with them. So what have you got to say?
The car was towed after there was a little I guess, back and forth
Now,
wording.
is that back and forth on audio?
Yes, yeah, it's on audio. I
How
believe
does that happen that it's on audio?
my office is fully recorded audio and video.
Okay. I'd like to hear a little of the audio.
Y'all stealing. Y'all coming in our neighborhood stealing. Yeah. Y'all coming in our neighborhood stealing. I'm so glad I got 200. Easy, no problem. Y'all not gonna keep that 200 though. Why?
Yeah, hello, towing. How can I help you?
They hustling hard. They're coming all. We gonna see a number of black people come in. They come in our neighborhoods and they're taking our. But I'm gonna show you that's gonna be more trouble than it is for that $200 y'all gave me. Look, right here. Look, give you that. Trump for president. Look.
All right, so, okay, so the police are in on it. It's racial, and what else?
When I got the car was damaged.
Okay, how was it damaged?
The car was damaged around the front bumper. I noticed the
Now, this is a loaner car that you'd had in your possession how long?
Correct. I had it in my possession about 5 days.
All right, so when you see your car, what's the problem with the car?
The problem was the bumper was detached from the front part of the vehicle, and I had to take that back to Lexus in that condition.
Did you photograph it at all, or you
Yes,
actually
ma'am.
took a video?
Yes, ma'am.
Is that video taken the second the car comes out?
Yes, ma'am. What? What? Look at it. Look at this. Look at this. Look at this. Look at this, officer. Look at this. 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 Nah. Look at this. Oh, hell no. Hell no. Hell no. Hell no. I want to make a report. No, I want to make a report, man. Look at that. Oh my God, man. Oh my God, no.
Okay. Had you hit that car before it got towed?
Absolutely not, Your Honor.
Okay. Was there any sign of damage that another car hit the car?
Absolutely not.
Okay. How do you suppose that happened?
When we pick up vehicles, before we touch the vehicles, we have to mark pretty much on the receipt before that receipt is
Let me
logged
tell you
in.
something. Just so you understand something. Because you've been in court how many times? I imagine a lot.
A lot, yes.
Right. Okay. Those little forms you guys do mean nothing to me because you can make them up after you get sued. Unless that side has a copy of it, please don't think for one moment that I can trust those forms. I see that those forms say that, in fact, the odd part is I can almost trust this form because what it says, show me the form. It's like marked incorrectly.
The receipt, do you mean?
Yeah, the one where you say where the damage is.
Well, a copy of this damage has to be, a copy of this receipt is left within the
Why don't
police
you take a
precinct.
copy of the damage when you pick up the car? That's what I keep asking you guys. If the damage is there when you pick up the car, why don't you just photograph it? Everybody has a cell phone. Y'all don't do it. This is the reason why cops now have videos on the car because they want to stop getting accused of stuff. So they just have the video on the car during the stop. You know, that's why so many departments are doing that. Why is it that your industry doesn't just take a picture of the purported damage before you tow the car? It's so easy. Why does, you got to take a, my daughter has a saying, my phone eats first. She has to photograph everything that's put in front of her at a restaurant because it's so pretty, and she has to photograph her eggs or she has to photograph her meat. But how is it that you guys don't just take a photograph? Now this is the ticket that he doesn't have a copy of because he wasn't around when you towed it, that says missing parts, okay? And then it says front bumper, and it has an X where the bumper should be. When you're there and you're having this argument with the fellow, what paperwork does he give you?
He gives me the receipt.
Can I see that?
And the ticket.
Is that it?
Correct.
Yeah. Okay, so this paperwork is given to you before you pick up your car.
Yes.
Okay, and in this paperwork, it has marked missing parts, which really I'm sure did mean, I don't know what it meant, but in between scratches and missing parts, and then it says front bumper. So for what it's worth, when the paperwork is filled out, someone's saying that the front bumper has already been damaged. What kind of damage does Lexus say happened? Like, do you have anything from Lexus?
All I gave you the estimate.
I have something from a company called the Collision Star
Yes.
Incorporated.
That's the estimate. right
Okay,
there.
and that is a place that Lexus took it to?
Yes.
And they are saying that there's $5,000 in damage. Now, the thing is, I'm just trying to figure out, it really becomes a question of, where this damage occurred. It's clearly damage. And there's clearly video of the damage from the second the car comes out. So what is your response to that?
It could have got damaged prior to me towing it.
Court's in recess.
All rise.
Welcome back to the People's Court. Harvey Levin here. So, who's responsible? The owner of the car says you damaged my car. The tow truck company. The tow truck company says pre-existing damage.
I think it's like everyone's problem if you didn't take pictures.
But somebody's got to win and somebody's got to lose. Does the tow truck company have to pay for the damage?
Yes.
Really?
They should have taken pictures before.
Well, that means they should lose then.
It's the burden of proof, right?
Huh?
The burden of proof. They have to prove it.
The tow truck company or the car owner?
The car owner. The car owner.
But you just said that who should take pictures?
Both parties.
But how does a car owner know to take a picture thinking that his car's going to get towed when there's no tow truck?
Because he doesn't know. He or she doesn't.
Okay, we're going inside the courtroom.
Okay. So my court staff told me that you just remembered that you had video of the car on the 15th. Yeah. How do you just remember that when you filed a lawsuit and you're so angry over everything that happened? How does that happen that you just remember that?
Yes, ma'am.
No, not you. How do you just remember that?
You talking to me?
Yes, I am. Aren't you the one who said it to my staff?
Yes, I did, because I just, when you said something about taking the pictures, I also have video of my car, and that's what made me remember it, because there was a scratch that we was talking about. So now that when I got out, because we don't remember the scratch, and like you said, it's a loaner car. So being that it was a loaner car, we said, let's take a picture, because what we had to decide.
Actually, you made another claim on this for this repair,
Your Honor,
right?
if I can.
Yeah, because I specifically asked you guys if this car was damaged before, and you said no.
No, it was not damaged. Now, those scratches, if you were asking me about...
But you had called the insurance company about it. Let me see the video.
Your Honor, if you allow me to...
I need to see that. No, I don't want you dancing. I want you answering. That's what I want.
Yes, ma'am.
So if I ask a question, I don't want you to start telling me some other stuff and give me some long-winded explanation.
I will give you
right now, I have
answer.
a specific question. This is the only question pending.
Yes,
show me the video you want to show me from the 15th. Because when I called the body shop, they said there are 2 claims in here. And when we asked, what do you mean 2 claims? Well, there was a claim on the 15th and a claim on the 17th. The car got towed when?
I don't have the receipt in front of me.
The 17th.
Should have.
A claim on the 15th and a claim on the 18th. That's what they said. The car got hit.
Absolutely not.
Did not get hit.
What?
Absolutely not.
I'm sorry. This is you pointing out how the car got hit. You're pointing out a scratch there. How do you think the scratch happened?
That's a scratch. You don't know.
How does a scratch happen?
Excuse me. We don't know how the scratch happened. That's why I was asking the insurance company a question, and that's how they turned it to a claim.
So tell me.
No, I want to make a report.
Why I'm seeing.
Hell no. Hell no. I want to make a...
The exact same damage. I don't see what the difference is between these 2 videos. In fact, I'd like you to show me. Can you get that video back on again and show me the difference? Get that video back on. That's what I want you to do. Okay.
Now that's...
Okay, so right here, you see that?
Yes.
You tell me how that is different from this. Tell me how. Come over here and show me how it's different. Hold on. You tell me how that is different from this.
That's not the damage.
Again. What is what?
How is the picture of this car different from the picture of this car? This is taken on the 15th before the tow, and this is taken at the tow site. This is the one that I have up. This is the one that your wife remembered all of a sudden that she had, and everyone forgot to tell me how on the 15th they had already called in damage to their insurance company. That's what I want to know. How's the difference between this and that?
Two things, right? Mm-hmm. The difference between these 2, I don't see what you're saying. There's only a scratch right here. That right there, what do you see there? What I see is a bunch of reflections. Here's the clear visions, right? You're not, okay. Go
ahead and go back to the lectern.
Oh my God.
What am I supposed to do with the fact that I asked you if this car was damaged beforehand? Specifically, I asked you that.
Your Honor?
Specifically, I asked you that, and you told me no, and I now find out that you called the insurance company about damage 2 days before. What am I supposed to do with that? What is a judge to think of someone who comes in here and under oath says, no, that car was not damaged beforehand, and then I catch that this estimate includes 2 different call-ins, 2 different claims, one before the tow, which then all of a sudden explains why the tow truck driver is marking front bumper damage, because as luck would have it, you had called in front bumper damage before the tow. And then you're at the tow truck company telling them that these $200 are going to cost them much more. Verdict for the defendant.
Wow.
Well, the judge has found for the defendant in this case. Mr. Moore, what are you thinking right now?
What I'm thinking is the fact that I called my insurance company to ask a question was turned into a claim. Because at the end of the day,
you're trying to rip
absolutely not. My wife and I are fine financially. There's no need for us to steal anything. In fact, when I spoke of them stealing out of our community, they used nefarious means. The real question should have been, who called in that tow?
Bottom line is, I think that second video kind of hurt your case.
Yeah, I think so, too. I think the second video hurt the case, but I think my case probably was already decided before I got here.
I can tell you that did not happen.
You can tell me that. I bet you can, Guy.
All right.
Thank you.
Very
Have
good.
a good
Okay,
day.
good luck.
Bye-bye.
All right, Mr. Graves. You get in court a lot of times. You turn a little bit. The camera's over there. We want to look at you. This case worked out in your favor.
Pretty much.
Were you worried?
Well, not at all. Most of them do. It's just another case where they're just trying to beat the tow guy for some extra money, I guess.
Okay. So
Justin's towing, we win. We're going to continue winning, and we won again today.
Okay, good enough. Congratulations. All righty.
By the way, if you lie in court, you can be prosecuted for perjury. That will do it for this case. Litigants for the next case on their way into the courtroom right now.
This episode is brought to you by Abercrombie. There's nothing better than the perfect jean and going out top combo, or an outfit that perfectly matches your plans. Abercrombie's relaxed jean goes with every occasion. Date nights with something lace, or daytime with a cozy sweater. And their barrel jean will surprise you. It's the trend that will become a staple in your wardrobe. Abercrombie denim comes in tons of rises, fits, and washes. Find your perfect pair online or in store.
The last thing you want to hear when you need your auto insurance most is a robot with countless irrelevant menu options. Which is why with USAA Auto Insurance, you'll get great service that is easy and reliable, all at the touch of a button. Get a quote today. Restrictions apply.
This is the plaintiff, David Koskoff. He says he hired the defendant's car service company to drive him and his wife to see a show in New York City, and the defendant never showed. He called and called, got no answer, and ended up missing the show due to the defendant's negligence. The defendant said she would reimburse him for the tickets, but she never did, and he's done fooling around with this slacker. He's suing her for the $2,500 he's entitled to. This is the defendant, Kathy. She says there was a mix-up dispatching the car, and the plaintiff was understandably upset. The plaintiff's been a customer for 10 years. She's never seen him behave in the irate manner he did that day, and he could have mitigated his damages by getting an Uber to the show. She returned the plaintiff's car service fee and certainly doesn't owe him $2,500 for tickets that cost him $99. She's accused of not being car-ful.
All parties, please raise your right hand.
Welcome back to the People's Court. Next case in the docket. The plaintiff hired a car to drive him and his wife to a show in New York City, and the limo was a no-show. So he wants the cost of the tickets to the show. But the defendant says he should have taken an Uber. It's the case of the show must go on.
Thank you, Douglas. David Koskoff?
Yes,
You
Your
are
Honor.
suing, let's see, the car service company represented here by its dispatcher, Kathy.
That's me.
Okay. And you have power of attorney to appear here by the owner?
I do.
Okay. You're suing them for $2,500, $99.30 in theater tickets that were wasted because they never came to pick you up, and $2,400 $1.70 for disappointment, inconvenience, and anxiety.
More or less, Your Honor.
Okay, what happened?
Well, the short of it is, well, about the more or less, the $2,500 is a figure pulled right out of the air.
Yes, I know.
Your Honor is the conscience of the community, and whatever Your Honor sees fit to award, I gratefully accept. The short of this case...
I smell a lawyer.
Used to be, Your Honor.
I could tell, man.
I'm 10 years retired. I haven't been in a courtroom since. The short of the case is, Your Honor, that I hired the car company to provide me transportation to the theater in New York City. They failed to show.
And what were you going to see?
Well, it was a show called Neurosis. Frankly, I don't think I would have liked it very much.
Well, I think it would have been right up my alley. So.
Well, the real reason we were going to see this show is a recent Yale grad that we had some contact with and some affection for was in the show, and he played the role of the character whose name was Neurosis.
Okay.
Brennan Caldwell was a student at Yale in the theater department, and we attend an awful lot of undergraduate theater. And we build much of our retirement around undergraduate theater at Yale. There are about 40 or 50 undergraduate productions a year at Yale.
Wow.
And we attend one every weekend, pretty much.
Good.
Students in the theater department at Yale are likely to appear in 10 or 12 shows over the course of the years that they're at Yale. And we see many of them several times and many times. And we become attached to some, and they to us, because we're regulars, and we're the only old people who regularly attend these shows, we stick out. These students graduate.
I love your retirement so much.
It's a wonderful
Hold on, I'm taking notes. Go on.
Anyway, these students graduate, they go to New York City, and they get jobs as waiters and waitresses. And sooner or later, they get cast in foolish plays like Neurosis, and they're held in...
I take it this was off Broadway?
Off
Broadway? Okay. So
anyway,
you hire this company to drive you to see Neurosis. You've dealt with this company a lot, right?
Yes, I've used them many times. I've always been satisfied with them. Their cars are clean, their drivers are courteous and competent, their price is reasonable.
And then they just didn't show up this day.
They failed to show up. Okay. And they were supposed to come at 11:45, and well, they were a few minutes late, so at 12 I called. But instead of getting the number for the car company, I got rolled over to a number that said, this is number, leave your name. So I didn't...
Who would that have been?
I don't know. Our main number rolls over to the secondary number, which that's the one that the owner answers.
The owner?
Yes.
And what happened? The owner didn't answer the phone?
What happened is that the phone was on vibrate, so it was a perfect storm. He was in church at the time. When he finally did get out of church, he realized that he had missed a call from Mr. Koskoff. He did return his calls and his voicemails. I guess it was like an hour later when he had returned the call. And
okay, but what happened with dispatch that dispatch didn't send a car?
Well, I was dispatching on that Friday. Lowell had given me the reservation. Lowell is the owner of the company. I had put him on schedule for that Sunday. I ran his credit card that afternoon on Friday. Unfortunately, Mr. Barnes, who is the owner, was also dispatching that weekend. And on that Sunday, he did not take a fresh schedule when he left on Friday. He took a dated schedule. So when he looked at Sunday's schedule, Mr. Koskoff's
so he's unavailable
was
and
not
took the
on.
wrong schedule?
Yes.
Okay.
Yes, unfortunately, I know.
Okay.
I know.
So does this couple have a duty to minimize their damages by jumping in an Uber?
Question again, Sarah?
Do they have to get an Uber to minimize their damages and go to the show?
No, I think they should be compensated somehow for the limo not showing up.
For the show?
The show, yes.
Okay, what do you say to that?
I think if they made the show, they shouldn't be compensated for the tickets.
Well, they didn't make the show.
Oh, well, then they should be compensated because it's the...
But they could have taken an Uber.
I think they should have been compensated.
Okay, going inside the court.
Mr. Koskoff originally wanted to be reimbursed for his theater tickets that were wasted.
Right. Mr. Barnes did try to offer to replace the theater ticket money, but I guess Mr. Koskoff was seriously angry, and it didn't work out, so they had hung up the phone. And I can agree, I understand him being upset, but it was an accident. He has used us for over 10 years. We have been a good company for him.
So what can you do for Mr. Koskoff? Certainly you should be reimbursing his theater tickets.
Absolutely.
But you want to keep his business?
If he wants to use us, of course.
Would you consider using them again if, say, they were to sweeten the pot by perchance throwing in, I don't know, what do you think? A free ride or 2 free rides? I have no idea.
I'm sure something could be worked out.
Let's work it out right now. That's what I'm here for.
We can offer, I know he goes down to the airport. We can give him a round trip fare back and forth to the airport.
And the theater tickets.
And theater tickets.
How's that sound?
Are you looking for a counteroffer, Judge?
Just for the fun of it, what would be your counteroffer?
My counteroffer would be 2 free round trips to Manhattan.
To Manhattan?
We don't go to we're not flying so much anymore.
All right, so he says 2 round trips to Manhattan. What say you?
2 round trips? I suppose Lowell will go for that. That's fine.
I knew you would say yes. You still got it.
Thank you, Your Honor.
Good luck, folks.
Well, the plaintiff negotiates a deal with the defendant. Kathy, how are you? How do you feel about the outcome here?
It's fair. It's fair. I want him to be happy. It wasn't anything we did intentionally. It was an accident.
I think everybody understands that. What would 2 round-trip tickets from New Haven into Manhattan and back be, worth?
About $400.
Okay.
And we get to keep his service.
And hopefully, he'll keep you as a client.
Yes.
Okay? Very good. Thank you very much. All right, appreciate it. Mr. Koskoff, if you'll step out of here. I can't help but ask you, sometimes accidents happen.
I appreciate that.
Do you feel if you'll step back a little bit, please, that maybe you're going a little overboard, suing just for this?
Well, I expected to get a check for the $99, and if I had, I would have licked my wounds and called it a day. But when I didn't get the check, I started getting madder at Lowell than madder, and so I brought a small claims writ.
Okay.
I hope that the agent for the car service and I are on the same wavelength. One way to Manhattan is $175. So 1 round trip to Manhattan would be $350, and 2 round trips would be $7, not $4. This says to me maybe we have a misunderstanding. But if we do, we'll see you back at the People's Court.
Thank you very much, sir.
Thank
Okay,
you.
hope you enjoy your free trips into Manhattan.
Thank you.
Okay.
Short and sweet, Doug. Everybody loves it when a judge can settle a case like this. And that will do it for this case. Litigants for the next case in the wind to the courtroom right now.
This episode is brought to you by Atlassian. Atlassian makes the team collaboration software that powers enterprise businesses around the world, including over 80% of the Fortune 500. With Atlassian's AI-powered software like Jira, Confluence, and Loom, you'll have more time to do the work that matters. In fact, Atlassian customers experience a 25% reduction in project duration per year. Unleash the potential of your team at Atlassian.com. Atlassian.
This is the plaintiff, Monica. She says she and the defendant lived together, and things didn't last long because the woman's a hothead. She yelled at her constantly. She wouldn't let her tomatoes ripen on the counter. Now the woman won't return her security because she said she had to clean the room. Ha! She's suing for triple damages in the amount of $5,000. This is the defendant, Mercedes Fernandez. She says the plaintiff never cleaned up after herself. She didn't put her food away, and she left dirty pots in her beautiful kitchen. The woman called the cops on her. She had to kick her out, and she's keeping her security to cover her unpaid rent and cleaning. She's accused of being too difficult.
All parties, please use your right hands.
Welcome back to the People's Court. These litigants live together, and the plaintiff says the defendant was so unreasonable she wouldn't let her tomatoes ripen on the counter. The defendant says the plaintiff was a slob. It's the case of hot tomato.
Monica, you've asked us not to mention your last name. You're suing your former landlord, Mercedes Fernandez, for $5,000. Triple the rent you paid, security deposit you paid, and punitive damages to get you up to that statutory maximum. What's going on?
Well, I wound up answering an ad to be able to look at the house, and we had a discussion about it. The rent was $580 a month, and I was specific about the places that I would be able to use and
in the house
to utilize various places in the house, garage, whatever, to store my stuff, because I have another business that I have a lot of tools and stuff for jewelry
What kind of business?
A jewelry business.
Okay.
And I paid the full.
How long did you live there?
Almost June, July, August, and some of September.
Okay. And at the beginning, did you guys get along?
Yeah.
And did you have a lease, or was this a month-to-month?
Yes, we did have a lease.
May I see the lease?
Yes, you may.
Okay, no. This is a receipt for $780. I'm asking you if you have a lease that entitles you to live there a year or 6 months or a specific term.
That's what we had that's what we had agreed to, is the year, and a year's lease at $580.
Where does it say a year?
It should be in there. I wrote it was a year or two we had discussed.
Okay. This doesn't qualify as a lease. What you had was a month-to-month. A lease is a specific beginning, middle, and end. It can't be, for 1 or 2. That's not a lease. In any event, when you live there for about 4 months, and then what happens?
Okay. I had paid the September's rent on the 15th. We were from the 15th on. And on the 22nd, she, out of the blue, just was sweeping the floor and told me that she yelled at me to come out of my room and told me that things aren't working out, and
but there had to have been some problem between you guys before that you sensed. I mean, there had to be something going wrong.
Yeah, there was. They had a puppy, and there was all sorts of problems with the poor puppy, and then the dog started before I even moved in, Mercedes gave me a ride to a few places, and that's where her daughter sent her a picture of the dog having vomited a sock. And later on, that was supposedly blamed on me, that the dog was eating my stuff, which wasn't accurate. And it just wound up being very, very difficult.
Okay, you have a different version of what the problems were between you two. What is it?
Her paint supply, she would keep it out on the night, and she wouldn't even put it away. She would just leave stuff outside, and she just wasn't clean, like the kitchen stuff. Like, she wouldn't even clean her dishes.
All right, so you told her then at some point you tire of it and you tell her you got to go.
Right. When I got tired of it is when she went into my daughter's room and just grabbed her charger, like taking my daughter's stuff.
How do you know she went into your daughter's room?
Because she left her a note, and my daughter told me, she left me a note, she took me my charger, like from my laptop. And I'm like, that's not right. That's when I got mad, and I went home and I told her, you need to leave. Because you cannot be going into my daughter's room and taking her stuff.
Did you go into her daughter's room?
No, I didn't. I even explained it to her, but she didn't want to listen.
All right, so there's a $400 deposit that she wants back. That's what started this whole thing.
Correct.
Okay. And why are you keeping her deposit?
There was substantially a lot of stuff in there. I mean, I even have a video of how bad that room was while she was living.
Show me the video of how bad. Let's see the video of how bad that room was.
And this was in July.
In July? Just a second. She left when?
In September. But this is while she was living there. So
why are you videoing her room? You're talking about her going into your daughter's room, and you're going into her room to video it?
Right, because the door was open, and then I saw it.
Oh, I guess you can just walk right in. It doesn't matter if she's paying rent.
No.
That seems like kind of an invasion of privacy.
That was during the move, Your Honor.
That was in July. But yeah.
It's an invasion of privacy. I don't care when it is.
Right.
Why are you keeping the $400?
For the cleaning of the room
Okay, so do you
and the
have any
mattress.
evidence of how she left it that would justify you keeping $400 of a
Yes.
security deposit?
I do. There's some pictures there.
Okay, what's that a picture of?
Of the molding, like it was not
Dust?
not cleaned. Yes.
What's that a picture of?
It's just more cleaning that she didn't do. Like I still had to go and thoroughly clean
That is
the
a picture of molding that needs caulking. Okay. What's that a picture of?
More cleaning that she didn't do. There's like dust and stuff in the.
That's not 4 months of grime. That's, years of grime. There's a mattress. What did you want me to see about the mattress?
The mattress that she messed up that was practically brand new.
Do you have a receipt for the mattress?
No.
How are you going to prove that it's practically brand new?
Because it was only a year old, but it's not brand new.
Did you ever send a letter to her as required by Florida law? You're from the state of Florida, and every state has different landlord-tenant laws that require, one thing or another. In your state, you have to write a letter within 30 days claiming a right to the security deposit and itemizing why. Did you ever write that letter?
I did not.
Oh, you didn't?
No.
What do you do if you can't get along with your roommate?
You set some ground rules to avoid confrontation.
That should be done at the beginning, but what do you do when you don't get along in the middle?
Well, it depends whose property it belongs to.
It's neither. They're roommates and tenants.
Well, you would have to compromise somehow.
Somehow, going inside the courtroom.
You now know that you're supposed to send a letter, right? You've since
Correct.
learned that? Okay. You tell me how a $400 case became a $5,000 case.
Because of the illegal eviction, I read in Chapter 83 that I'm allowed to get 3 times the month's rent for the illegal eviction. And I was out by the 15th.
What's
And
the illegal eviction?
I was not allowed to come into the house. She wound up locking me out. She changed the locks.
Wait. When did she lock you out?
Probably the 8th of September.
Okay,
She
did
started
you lock her
locking
out
me
on
out.
the 8th of September?
I did not.
When did you lock her out? I don't like
I
the way you
didn't
answered.
lock her out. I have a text message, her stating that she vacated, was evicted. She said, I vacated on this day.
What day?
On September 18th was
Okay,
when she
but
said
my question
that.
to you is, did something happen on the 8th where she couldn't get in or something?
No, she kept calling the cops about 9 times, and the
For
cop
what?
says because she was saying that I was illegally evicting her and then whatnot. So the cop says, you can't throw her out. You don't have an eviction notice. You have to go the proper way. So she had access to the house because the cops either way would not let me.
No, you can't physically throw her out.
Correct.
You have
And
to go
that's
through
exactly
court.
what this
In
is.
other words, if she doesn't leave, see, you're confusing her saying, I want you to leave, with her picking you up by the ankles and the neck and throwing you out. So she has a right to tell you, I want you to leave because you don't have a lease. And then if you feel like staying and making her go through the court process, it's a very unpleasant way to live. I don't recommend it. But if that's what you feel like doing, then yes, she would have had to go to court. But that doesn't make it an illegal lockout that she didn't file a notice. That's not how this works. Now, there's no triple anything. There's no punitive damages. You have some videos you wanted me to see. What am I going to see in the videos that you wanted me to see?
That's just the state of her room and her trying to make criticisms of me. And before I moved in, that's what her place looked like. And I saw how her daughter's room was, and her room was, the sheets were all over. The bed was never even covered up.
Daughter, come on up. How old are you, honey?
12 years old.
How old?
12.
Aren't you really glad this is over?
Yes.
Okay, go ahead, sit down, baby.
Thank you.
All right, folks, you don't get a right to keep the security deposit for the things that you were showing me there. Unless you can prove that this is a new mattress and she damaged it, you don't get a right to do it. And what you showed me was like dust and dirt, which is like really nothing. And even if you had written the letter, you couldn't do it because what I'm seeing doesn't justify it. But then on top of that, you didn't write the letter, so you have zero right to do it because you have an obligation as a landlord in the state of Florida to write the letter within the 30 days, okay? where you're coming up with triple cost of rent and all these other things are just made out of. They're just, no. So I'm going to order you to return the $400 security deposit. Plus, I'm also going to order you to pay prejudgment statutory interest since the time in September when you should have paid the $400. That's my verdict. Good luck, folks.
Thank you.
Well, the plaintiff is going to get some money back, not nearly the $5,000 she was seeking. Ms. Fernandez, you should have written that letter, you know?
I should have, but, you know, we have to follow the laws now, and now I know.
And you didn't follow the law. So
That is right.
You've learned something. Are things better now with her not there?
Absolutely.
What's the big difference?
There's no mess in the house. It's always clean. And when I get home, there's not socks thrown everywhere, and my puppy is not getting sick. So it's all good.
So life is better.
Yes.
All right. Well, thank you very much. You must sign a
Thank
few
you.
documents on your way out. All right, Monica. You got what you wanted, partially.
Partially.
$400, not $5,000.
Right, right.
You okay with that?
I'm okay with that.
All right.
At least I don't have to live where there's ants and roaches crawling all over the place, and I'm accused of it.
How could you have stayed there with that, as long as you did?
It was difficult, but I had the hopes of being able to continue my business while I was on my off time from my work.
What were you teaching? Art classes?
I was teaching some paint pouring.
Yeah.
And I was
Paint
also
pouring?
Yeah.
What's that?
It's a new technique for creating paint for those of us who can't paint with a brush.
Okay, all right, very good. Well, thank you very much. You must sign a few
Thank you.
documents on your way out of the courtroom, and that's it. Harvey?
You know, Doug, what this gentleman said about compromising, you sit down and you say, look, if we can't compromise, let's negotiate an exit that works for both of us.
Don't text and drive. The People's Court is a Ralph Edwards, Stu Willett production.